Hello, everyone, and welcome to ACS webinars, connecting you with the best and brightest minds in chemistry, live from Washington, D.C. I'm Michael David, and I am pleased to be your host for today's broadcast, which is being co-produced with ACS Professional Education. Teamwork makes the dream work, but how can you make sure that your contributions and IP will be properly protected when forming partnerships? Today, we will be joined by attorney and ACS Pro Ed instructor, Bob Migliorini, as he shares how to protect your technology and IP interests by making sure the appropriate agreements are in place from the start. We would love to get you involved in the discussion, and you can share your thoughts and questions in the questions panel. You can also join the discussion on Twitter by including @Americhem Society in your tweet. The slides for today's webinar can be accessed right now by clicking on the link you see in the GoToWebinar control panel, or alternatively, going into the handout section and downloading it from there. And an invitation email to view the unedited recording from today's presentation will be sent to all registrants after it is over. Our moderator for today is Brian Tweedy, a senior manager with ACS Learning and Career Development. In this capacity, he has general management of the organization's professional education and training, as well as career services and leadership development programs. And with that, Brian, I will turn it over to you.
Thanks, Mike. In the business world, protecting your IP is critical. ACS Professional Education is here to provide you with some tips and tools to do this with today's webinar. Our speaker today, Bob Migliorini, is an in-house intellectual property attorney with ExxonMobil Corporation. He provides counsel to his clients in IP law, including patent preparation and prosecution, patent opinions, client counseling, and IP agreements and licensing. He is licensed to practice law in various states and before the U.S. Patent and Trademark Office. Mr. Migliorini is also an adjunct law professor at Pace University School of Law in White Plains, New York, where he teaches courses in patent practice and procedure and IP agreements and licensing to law students. With that, I hand this over to you, Bob.
Thank you, Brian. Welcome, everyone. So we're going to get started with this primer with regard to intellectual property agreements, fundamentals for scientists, engineers, and managers. First of all, just a disclaimer with regard to the materials I'm going to present today. These are my personal compilation of instructional materials. They don't necessarily reflect the information or instructions of the employer that I work for. They're not intended to be legal guidance. They're provided to be educational in purpose. If you have specific questions with regard to intellectual property agreement issues, I would advise you to seek the counsel of an IP attorney in this regard. But hopefully you'll find the materials very useful with regard to your future interactions and work with regard to IP agreements. So what we're going to go through today is basically a just brief summary of a couple of the topics that are going to be covered in the more detailed course, which will be offered in June. In terms of the agenda for the detailed course on IP agreement fundamentals, I'm going to go through that agenda, and we're going to cover a couple of those key aspects today during the next half hour to 45 minutes. So in terms of the detailed agenda, we cover an overview of agreements, and in particular, intellectual property agreements in terms of why we need these types of agreements, what are some of the key principles involved with them. We do a review of the anatomy of an IP agreement in terms of the major parts of the agreement. We then go through the various types of IP agreements that we're going to cover in the course and talk about some of the common provisions that cut across all of the various IP agreements. And then we focus on some of the important IP provisions that need to go into intellectual property agreements. Then we delve into in detail in terms of some of the specific IP agreements that are quite frequently used in businesses, in particular, confidentiality and non-disclosure agreements in terms of an overview of them and their use, some of the important provisions in those agreements and negotiation issues, Then we go through an exemplary confidentiality agreement. Then we segue into material transfer and testing agreements, again, looking at an overview of their use, some of the key provisions in those agreements and negotiation issues with another party. And during the course of the detailed agenda, we also have some practice exercises introduced to help reinforce some of the educational materials that we cover. Then we get into some more complex agreements that are quite frequently used in business and technology, such as collaborative research and development agreements, technical service agreements, and consulting agreements. Again, for each of these agreements, we overview how they're used, some of the key elements and provisions in these agreements, and some negotiation issues. And then finally, we talk in detail about IP license agreements. Again, from the perspective of overview and use, some of the key elements and negotiation issues, and we talk about a couple of ancillary types of documents that can be used with IP license agreements, such as terms of reference and letters of intent. And then finally, within the detailed course, we go through an IP agreement process step in terms of a staged approach and working with another party on IP agreements, some guidelines for negotiations with another party, also discuss key considerations after the IP agreement is put in place with the other party in terms of to have a successful outcome. And then finally, best practices for working with IP counsel with regard to these types of agreements. So in terms of what we're going to cover today, we are going to take a look at some introductory materials on IP agreements. We're going to look at the anatomy of an IP agreement, and then we're going to talk a little bit about, in particular, confidentiality and non-disclosure agreements. So to start off with the big picture in terms of what is an agreement. An agreement is a mutual understanding between two or more parties about their relative rights and duties regarding either past or future performance. So typically, an agreement will cover future performance in terms of how the two or more parties are going to interact with each other and what they're going to do and not do. So generally, an agreement sets out rules of conduct between two or more parties regarding an obligation to do or not to do something. There are four important things that need to be included within the agreement for it to be an enforceable agreement. The first is there has to be an offer by one party. That offer has to be accepted by the other party to the agreement. And so when we have an offer and acceptance, we need to have mutual assent to the deal between the two parties. And lastly, to have an enforceable agreement, there has to be some consideration between the parties. So what is consideration? It's a bargain for detriment that will pertain to at least one of the parties. So for example, if I do work for you, you will pay me for it. So that the offer is to do the work, and the bargain for detriment is to get paid for the work that you do for the other party. So what is the difference between an agreement and a contract? So a contract is an agreement that is enforceable or recognizable at law. So keep in mind that not all agreements are enforceable. That is not recognizable by law. So if you have an agreement to do something that is illegal, so something that would break a law, that would be, can be an agreement, but it would not be a contract. Or an agreement that is impossible to perform. So if you have an agreement with another party to, for example, develop a perpetual motion machine, that would be, you can have an agreement, but it would not be a contract because it would be something impossible to perform. We can also have one-sided agreements that are not contracts, and one-sided agreements, an example of that would be an offer for a gift. So for example, if I give you a car, I will give you a car for your birthday present to someone. If you make that offer to them, that would be a one-sided agreement because there would be no detriment to the receiver of the gifts, to the person who's receiving the car. unless the person that you make that offer to detrimentally relies on that offer. And because of the detrimental reliance, that could create an enforceable agreement that would be construed as a contract. So now that we understand what is an agreement, what is a contract, next we need to understand, well, what is an IP agreement? So an IP agreement or a contract is a business agreement or exchange between two or more parties that involve intellectual property rights and intellectual property obligations. So what do we mean by intellectual property? So there are 5 important pillars to intellectual property. Those include patents, trade secrets, trademarks, copyrights, rights of publicity, and importantly, a lot of IP agreements and contract include 2 or more types of intellectual property and are known as hybrid types of IP agreements. So you could have an IP agreement that includes both patents and trade secrets. So now I'll turn it over to Mike to present a polling question to the audience to get some audience input in the discussion.
All right, well, thank you so much. Our first question for all of you is, do agreements related to intellectual property have to be in writing in order to be enforceable against the parties? And you can go ahead and click directly on one of those white buttons you see on the blue screen to let us know what your response is. And I do see some results coming in now. While you are entering those in, I do want to remind you that we are going to have a Q&A session at the end of the presentation today. And we are excited to get your questions for that. Feel free to ask your questions as soon as they come to you. No need to wait until the presentation is over to begin asking. And with that, I am going to close this poll in 5, 4, 3, 2, 1. And it looks like we had 60% of the audience say yes, 25% said no, and 15% said maybe. So Bob, I'll turn it back over to you to let us know what the correct answer is.
Okay, thanks, Mike. So the correct answer to this, we're going to review on this slide. So we can have IP agreements that are put in various forms. So we can have IP agreements that are put in a written form, in particular in the form of a single type of document. So we can have a formal agreement between 2 parties, a contract. We can also have an IP agreement that is as simple as provided on the back of a napkin between 2 parties, or provided on a presentation, or even a sign-in sheet where the parties sign something. Another common type of written intellectual property agreement is a click-wrap agreement as it relates to software. We can also have written IP agreements that are in the form of multiple documents. So a collection of documents that combined together would form the basis of the intellectual property agreement. So a combination potentially of purchase orders, invoices, and email correspondence between 2 or more parties. So with these multiple document types of written agreements, sometimes it's difficult to know exactly what the terms and conditions are precisely because of potential conflicts between the documents, and it may come to a battle of the forms in terms of, what are the actual terms and conditions. And then lastly, we can also have oral intellectual property agreements where there's 2 parties that come up with an oral type of an agreement, and as long as there's an offer, acceptance, mutual assent between the parties, and there's some consideration, that is some detrimental reliance on the on the part of one of the parties, we can also have an enforceable oral intellectual property agreement. So the answer to the question, the previous polling question, is maybe. Written agreements are vastly preferred to oral agreements, and in particular, written single documents in the form of IP agreements are preferred to written multiple documents from a clarity standpoint and enforceability standpoint. However, by law, some types of intellectual property agreements have to be in writing. So a non-intellectual property agreement that has to be in a written form is any transfer of ownership of real property. So if you go to sell your house, you go to sell real property, your land, it has to be in the form of a writing to be an enforceable agreement. With regard to intellectual property, if there's going to be a transfer of ownership of patents and patent applications, that type of an agreement also has to be in a written form to be enforceable. But again, not all agreements have to be in writing to be enforceable. We can have oral agreements as we discussed. An example of an oral agreement can also occur based upon implication by equity. So if there's an unconscious accident victim, they would be held responsible for the medical care that they're administered, even if they had no way to agree to that medical care because they were unconscious. We can have also intellectual property agreements that are implied by law. So for example, if you go to purchase a product that's covered by a patent in an unconditioned sale, you would have an implied license to be able to use that patented product without risk of being sued for patent infringement by the company that sold that particular product. So that would be an implied by law or implied license that you would have based upon the purchase of the patented product. So why do we need intellectual property agreements? Oftentimes they're necessary to work with other parties. So working with other parties can provide benefits, can lead to competitive advantage, can help a company enable or an entity enable new technology in a market, so expand into a new geographic area or into a new product line area. Can also assist with the deployment of new technology to the business. So for example, new manufacturing processes that you may use internally. Can also are used quite often to help build and complement knowledge and expertise within your organization by seeking the assistance of others. So they help to increase leverage of another party who has, quite frankly, experience in technologies that you may not have internally via collaboration with the other party. So we need a clear business objective for why an IP agreement is necessary at the onset. So we don't want to enter into IP agreements just for the sake of having an IP agreement. We need a clear business deal and why we want to collaborate with another party before trying to enter into an IP agreement with that party. So IP agreements, in terms of their purpose, help to facilitate transactions by documenting deal points between the parties with regard to collaboration. They help serve as a roadmap for the parties to follow with regard to performance of a particular project that you are doing with another party. If we have a poorly drafted intellectual property agreement, it can strain relationships between the parties, which will ultimately jeopardize the overall business objectives and can ultimately lead, in a worst case scenario, to litigation between the parties. So it's really important to draft and negotiate a high quality IP agreement that works well for both of the parties and that will lead to the success of both of the parties to the agreement. So the next thing I'd like to cover is the anatomy of an intellectual property agreement in terms of the major parts that cut across a number of the various types of intellectual property agreements. So the first major part of an intellectual property agreement, and should be of any type of enforceable contract, is a preamble or an introduction. So in this section of the agreement, it's the beginning part of the agreement. It identifies the parties to the agreement and can also include the effective date of the agreement. So I give below here an example of an exemplary preamble where we have party one with a certain principal place of business. In this case, it's a university, and party two with another place of and party 2 with another principal place of business with an effective date of the agreement. So this introduces, well, who are the parties to the agreement? Then after that, it's good practice to put recitals or a background section into the agreement. So this can be structured as a series of whereas clauses or a background section that would set forth the background of the relationship between the parties. So this would be the facts and circumstances that have led to the parties entering into this particular agreement, and is used oftentimes to determine the intent of the parties to what the agreement covers. The recitals or background section is generally not binding on the parties. They're not treated as covenants. So an example of some exemplary recitals are shown below here, where we have the university has developed new tennis racket frame technology and has applied for patent protection on this technology. And whereas the racket company desires to manufacture tennis rackets based on this technology at its facilities in Texas and distribute those rackets in the European markets. And so this is the background that would lead to potentially a licensing agreement between the university and racket company with regard to new tennis racket frame, new tennis racket technology. So the next section of the IP agreement is the definition section. These would be key terms that are used throughout the agreement. Any definition should be set out in either initial or full caps. And these would be important business terms or technical terms that need to be clearly defined in the agreement. So it's clear to both parties what these terms or phrases mean. So in drafting the contract, the attorney can be his or her own lexicographer, so they can define terms as appropriate for the contract. In terms of where we put the definitions, generally we put them at the beginning of the agreement. They can also be alternatively embedded throughout the agreement, or even alternatively put as an appendix to the agreement. So I give here at the bottom of the slide some exemplary definitions. So we can have in a licensing agreement where we have a definition of what constitutes licensed patents, they would be listed in a separate appendix to the agreement. Also an example of how we want to specifically define a motor as it relates to this agreement. Again, different from what a dictionary definition would be. But would be more appropriate to the parties to the agreement. Also specifically defining net sales, for example, in a licensing agreement. So the next section of the IP agreement is probably the most important, and it's the binding covenants or provisions. So these would be the immediate rights and obligations of the parties to the agreement. So this is the heart of the contract. Would also have remedies in terms of what happens if one of the parties doesn't do what it's supposed to under the contract. We like to take the binding covenants or provisions and put them in separate paragraphs or articles for ease of reading. And then finally, at the end of the agreement, we have an execution section of the agreement where we get the parties to sign the agreement in terms of having a person with the authority to bind the particular party with regard to the agreement that they're signing. The parties can sign the agreement in a variety of ways. The agreement can be signed sequentially by the parties or simultaneously. We can use the mailing of original documents or even fax copies for signing. And over the last few years, electronic signatures have become much more prevalent and streamline the process of executing the agreement using such things as DocuSign or Adobe Sign. So during the detail course, I cover a number of different types of IP agreements in detail, in particular confidentiality agreements that I'm going to talk about in a little bit more detail, material transfer agreements that enable a party to test the non-commercial products or experimental products of another party, Also, we discuss joint or collaborative research and development agreements to enable R&D collaborations with university, governments, and other commercial entities. If the joint collaborative research and development agreement also involves potentially commercial products or processes, then it would be known as a joint development agreement. With these types of agreements, IP rights are very highly negotiated. Also go through technical services agreements that enable a party to get technical support. So for example, engineering services, testing services from another party. The agreement would specify the services and also contain some related IP provisions. We also cover consulting agreements to enable acquiring consulting services from individuals who have specific area of expertise that we need help within. And then lastly, licensing agreements that enable licensing of intellectual property, both into an organization and outside of an organization with another entity. So with these licensing agreements, they're quite prevalent as it relates to patents and patent applications and also trade secrets. And provide the party that has a license to the intellectual property of another party to use that intellectual property under certain defined terms and conditions. So now we're going to segue into a little bit more detail about non-disclosure agreements, and I'm going to turn it over to Mike for another polling question.
All right, so our next question for you all is, what should a non-disclosure agreement or a confidentiality agreement do at a minimum? Should it define what information is confidential, limit the scope of its use, restrict its disclosure onward, or provide a punishment if broken? And I am seeing the results come in now, and we'll be closing this poll in 5, 4, 3, 2, 1. 79% of the audience said define what information is confidential. 26% said limit the scope of its use. 42% said restrict its disclosure onward, and 32% said provide a punishment if broken. And with that, Bob, I'll turn it back over to you.
Okay, thanks, Mike. So let's do an overview of confidentiality agreements. So a confidentiality agreement is defined as a binding contract between two or more individuals or entities where we have at least one party being a disclosing party, referred to as disclosing party or disclosure. And that party agrees to provide the other party, referred to sometimes as the receiving party or the recipient, with certain confidential information. With the receiving party agreeing not to disclose that information or use that information in a manner other than what is called for in the agreement in terms of for a limited purpose. So with any confidentiality agreement, we need to be clear who the disclosing party is. That is the party that has the confidential information that is being provided to the recipient, and who is the receiving party. That is the party receiving the confidential information of the disclosing party. So this type of agreement also serves for the orderly return or destruction of the confidential information supplied by the disclosure to the recipient, and details the obligations, which we're going to cover regarding what the receiving party has to do to safeguard the disclosing party's information. So at a minimum, a confidentiality agreement has to do 3 things. It has to define what information is confidential of the disclosing party. It has to limit the scope of its use by the receiving party. And it has to also restrict its disclosure onward by the receiving party. So these types of agreements are also referred to as non-disclosure agreements, or NDAs, or secrecy agreements, or confidential disclosure agreements, or CDAs. Various industries, various companies use different designations for these types of agreements. We need to be clear in terms of the difference between a one-way or a unilateral confidentiality agreement. So with this type of an agreement, only one party is disclosing confidential information to the other party to the agreement. So we have one disclosing party, one receiving party. In contrast, sometimes we have what is referred to as a two-way or a mutual or a bilateral non-disclosure agreement. And in this case, both of the parties are exchanging and disclosing confidential information. So if there's two parties to the agreement, each party is both a disclosing party and also a receiving party. So with this type of agreement, it enables disclosure of confidential information to another party. So if you are disclosing the confidential information to another party, from your perspective, it would be a one-way out confidentiality agreement. If you are receiving the confidential information from another party, from your perspective, it would be viewed as a one-way in confidentiality agreement. And if both parties are both disclosing and receiving confidential information, it would be a two-way or mutual non-disclosure agreement. So confidentiality agreements are one of the most frequently used type of intellectual property agreement. They're used to safeguard valuable and commercially sensitive information when dealing with other parties. Sometimes confidential and proprietary information are used interchangeably. Proprietary information can be broader than confidential information and could also include information that is not confidential, such as the book is the proprietary information of its author, but may not be confidential. So the thing to keep in mind with this type of an agreement is that if you are working with another party and there's no confidential or proprietary information being exchanged between you and the other party, then a non-disclosure agreement is not needed. So a non-disclosure agreement or a confidentiality agreement is only needed when one of the parties is disclosing their confidential information or proprietary information to another party. So again, not always needed when working with another party. People think, well, if I'm going to work with another party, then I have to put in place a non-disclosure agreement. Again, you can have exchanges with another party that doesn't require the use of a confidentiality agreement. So some questions to consider and specify in the agreement that we're going to cover in more detail is, what information is confidential? For what specific purpose will the information be supplied from the disclosing party to the receiving party for? Are there any exceptions to the definition of confidential information? And are there going to be any permissible disclosures of confidential information that the receiving party receives from the disclosing party? So confidential information can relate to a number of different types of intellectual property. It can relate to inventions, can relate to information that is contained in pending unpublished patent applications. So once a patent application publishes, then it goes into the public domain and would not be confidential information. But before it publishes, if you file a patent application, it would still be a trade secret. Can also relate to things that are non-inventive in nature, such as trade secrets. So such things as processes and business strategies and methods, even customer lists and collections of data, and physical devices and articles, product samples, computer software. Again, trade secrets can be very broad in scope. And again, any information that an entity has that provides them a competitive advantage from their competitors not knowing of that information can be a trade secret. So in the confidentiality agreement, we define the scope of the obligations on the receiving party regarding the confidential information, provide a length of time over which those obligations will be enforceable. This is an exemplary structure of a confidentiality agreement. Again, some of the important provisions are shown here, starting off with the preamble, then the defining what the confidential information is of the disclosing party and the purpose of for its disclosure to the receiving party. Having exclusions for what doesn't constitute confidential information, and then the very important obligations of the parties that receive the confidential information. Also, sometimes good practice, depending upon the information that's being exchanged, to consider putting in IP provisions. And then there would be a host of miscellaneous, what we sometimes refer to as boilerplate provisions as part of the agreement. So the preamble of the confidentiality agreement should clearly define the parties and the effective date. So oftentimes with a non-disclosure agreement, we refer to one of the parties as the disclosing party and the other party as the receiving party. We have to clearly identify the parties to be sufficiently certain, unless so that if there becomes a later controversy in terms of who are the parties to the agreement. So with regard to individuals, we should identify their full name and address. With entities, it's good practice to put the name of the entity, their principal place of business. The effective date can also be put in the preamble. If there's no effective date indicated, then the effective date would be the date signed by the last of the parties to execute the agreement. The heart of the confidentiality agreement is the confidentiality provision that should detail who is disclosing the confidential information, whether it's going to be a unilateral or a bilateral. So is there just going to be one party disclosing confidential information to the other party, or both parties exchanging confidential information? Should also clearly detail what the business purpose is for the agreement in terms of why the parties need to disclose confidential information. Should also have what is to be held in confidence. And this is where it's important to define what confidential information is being provided by the disclosing party. So a broad definition of confidential information would favor the disclosing party. Should also indicate that if there are any oral disclosures of confidential information between the parties, whether those oral disclosures need to be followed up in the form of a writing from the party that discloses orally to the other party receiving the information to certify that the information is confidential in the form of a writing. Also, again, the purpose for providing the confidential information. A narrow purpose defined in the agreement would favor the disclosing party. Then we would have the important obligations and who was obligated, for what period of time those obligations would apply. The confidentiality provision is used in many types of IP agreements. So they're used in consulting agreements, licensing agreements where there are trade secrets, even collaborative research and development agreements utilize confidentiality provisions. So having a good understanding of confidentiality provisions carry over to a host of different types of IP agreements. So the confidentiality provision also should exclude certain information from what is confidential information. So oftentimes simple NDAs that you pull off the internet leave out these exclusions. These exclusions are based upon established principles of law and it would include any information that is already in the public domain, such as if the information was already in a publication or a presentation or was generally known, then it can't be confidential information, or information that is already known to the receiving party, or information that was acquired by the receiving party from a third party by lawful means independent of the particular confidentiality agreement. Or the exclusion would apply if the information was independently developed by the receiving party. These exclusions can also have permissible disclosures under the agreement, such as that the receiving party may have the ability to disclose the information to their affiliates or contractors or consultants. And also exclusions if required by law. So if there's a court proceeding where the information is not privileged, the receiving party may have to disclose it as part of the court proceeding. Or if it's subject to disclosure to a government authority under some type of compelled disclosure. So let's get to our third and final polling question, and I'll turn it back over to Mike.
All right, our final polling question is, and I'll launch this now. If there is less of a burden, is this following statement true or false? There is less of a burden with receiving the confidential information of the other party to a non-disclosure agreement than disclosing the your confidential to that party. And is that yes, no, or maybe? And I'm seeing the results come in now, and we'll close this in 5, 4, 3, 2, 1.
Okay, so the answer to this question.
Yeah, we had 44% say yes, 38% say no, and 19% say maybe. So with that, Bob, I'll turn it back over to you.
Okay, and the correct answer to this question is generally no. So there's more of a burden on the party receiving the confidential information of the disclosing party than vice versa, due to the obligations that the receiving party has to properly safeguard that information. And we're going to go through those obligations now on the party receiving the information. So in simple agreements, the receiving party may just have to hold and maintain the confidential information of the disclosing party in strictest confidence for the benefit of the disclosing party. With this type of simple statement, there's no restricted use for the purpose only on the receiving party. Oftentimes, though, in a well-drafted confidentiality agreement, the obligations on the receiving party are significantly more and would include a restricted use of the confidential information, in particular, the ability to use the confidential information only for the purpose stated in the agreement, and also would specify the time period that the receiving party has to hold that information in confidence. So I give here at the bottom of the slide a more detailed example of obligations on the receiving party with regard to protecting and safeguarding and the confidential information of the disclosing party and only using it for the specific purpose of the agreement. Other types of obligations can include restricting access of the confidential information to those who have a need to know for the purpose stated in the agreement. So the receiving party can only access the information or provide it to individuals within their company who have a need to know the information. We can also allow for exceptions for the disclosure of the information to affiliates, as long as the affiliates of the receiving party are bound to as stringent of obligations of confidentiality, at least as stringent as the particular confidentiality agreement. Also, obligations on the receiving party to return, destroy the information upon expiration or termination of the non-disclosure agreement. The next topic I'd like to cover is IP provisions and IP considerations with regard to non-disclosure agreements. So most form type NDAs are silent in this regard. You may want to think about IP provisions where the confidential information exchange between the parties may lead potentially to inventions. So inventions that come about as a result of the NDA can be patentable, or they could be potentially maintained as trade secrets. So by its nature, the filing of a patent application would constitute a public disclosure. And if part of the application, that is the patent application, is based upon the confidential information received from the other party, that could potentially result in a breach of the agreement or breach of contract. Oftentimes it's good practice to maybe put an express statement in the agreement not allowing for the filing of patent applications by the receiving party as it relates to anything that would be exchanged under the confidentiality agreement. Also, if it's a one-way non-disclosure agreement, allowing for having an express exception that would allow for the filing of patent applications by the disclosing party based upon the technical information that is generated under the non-disclosure agreement. So those are things to consider with regard to, again, whether the receiving party, in terms of explicitly not permitting the receiving party to file patent applications, and also expressly permitting the disclosing party to be able to file patent applications. We also need to consider with regard to intellectual property. Options for protection of the IP by the receiving party by the recipient with the disclosure's confidential information. So if we have a one-way non-disclosure agreement where the disclosing party is providing confidential information to the receiving party, and the receiving party maybe derives an invention based upon the confidential information that has been provided to them. The disclosing party should think about getting some type of protection in the agreement with regard to those inventions derived by the receiving party with the disclosing party's confidential information. One possibility is for the receiving party to assign any of those inventions back to the disclosing party. So that would be preferred for the disclosing party. As a fallback position, another option would be where the receiving party gets to still own the invention, but would provide a non-exclusive worldwide royalty-free license or a grant back to the disclosing party, so the disclosing party would still have a right to practice those inventions. So it's good practice to provide, again, if there's the possibility or good probability of potentially inventions coming about, to consider including these types of provisions in the agreement. You would want to include a notice provision where the disclosing party would provide notice of the invention, or the receiving party would provide notice of the invention to the disclosing party within a certain time frame. I give at the bottom of this slide an exemplary assignments of invention clause from the recipient or receiving party to the disclosing party, as well as an exemplary license grant back provision or clause from the receiving party to the disclosing party. The final slide that I'd like to review is with regard to survival obligations. So these are obligations that would extend beyond the term or expiration of the agreement and for how long thereafter. So probably the most critical survival obligation relates to the confidentiality obligations. So if the term of the confidentiality agreement is only, say, a year or 2 years long, the disclosing party will want the obligations of confidentiality on the receiving party to extend beyond the term of the agreement. In particular, if the confidential information has a life that extends beyond the term of the agreement. So other common survival obligations relate to export controls, intellectual property rights, disclaimer of warranties and limitations of liability, and also choice of law and forum. So survival obligations of confidential information tend to be pretty contentious sometimes in these agreements. The receiving party generally wants to try to minimize the obligation as short as possible, so 2, 5, or 7 years. And the disclosing party, who's disclosing their confidential information to the other party, wants to try to maximize it, maybe 10, 15, 20 years, or potentially evergreen, which means forever. So industries with long technology development and commercialization times may want longer periods as it relates to the survival period for confidential information. In some industries, trade secrets may be very short-lived, and so they're willing to have a very short confidentiality term or duration. So one good question to ask is, for how long will it take for others to independently discover the confidential information if you are the disclosing party, and kind of use this as a guide in setting the confidentiality period within the agreement. If a period isn't specified, then evergreen or forever would be implied. And I give at the bottom of the slide an exemplary survival of obligations clause where the certain clauses, including confidentiality, would terminate 20 years from the expiration or termination date of the agreement. So a fairly long period of time. Then I have an exemplary one-way non-disclosure agreement, an exemplary two-way or mutual non-disclosure agreement. Additional resources are shown on this particular slide. And with that, that's a brief primer on the Intellectual Property Agreement Fundamentals course. I will now turn it over to Brian.
Thanks, Bob, for providing us with these practical tips for protecting intellectual property. Before we begin the short Q&A session, I want to point out that professional education is a variety of courses to help advance your career. Our speaker today teaches two of our courses, as you'll see on the slide, Patent Law Fundamentals and Intellectual Property Agreement Fundamentals, and both are open for registration today. To find out more about the courses and register, please visit proed.acs.org and navigate to our online live courses. And now let's begin the question and answer session. So Bob, Lori asked, how do you manage these IP agreements between entities in different countries with differing IP laws?
So that's a really good question. So oftentimes in negotiating agreements with an entity in another country, in the provision that is sometimes highly negotiated is what would be the choice of law and choice of forum. So if there's a dispute between the parties, whose laws will apply, where will the dispute be litigated? So obviously, if parties from two different countries would want to have their particular laws of their country be the basis of what law would apply with regard to the contract. Sometimes there's arbitration provisions put in the agreement to try to avoid litigation or mediation, so alternative dispute resolution techniques. But choice of law, choice of forum is probably the biggest issue that sometimes comes into play with working with entities outside of the U.S.
Okay, great. So Peter asked this question: would independently developed information be excluded from an NDA if that information was developed during the term of the agreement?
Yes, if it could, that would fall under one of the exclusions that I covered with regard to what doesn't constitute confidential information. Again, you would have to provide evidence to that it was independently developed, that it wasn't something that was result of commingling of the other party's information with your information. But yes, that if it was truly independently developed, that would be an exclusion.
So Robert asked a question regarding enforcing IP agreements. So if you're a small company, what would your recommendation of enforcing an IP agreement versus a large company or a large entity?
Well, I mean, I guess enforce, always try to, if you have a dispute with the other party to the agreement, you always try to work things out without getting the lawyers involved. So that would be my first approach, is to try to resolve those issues. And then based upon how that goes, then you'd need to look to the agreement and see what what provisions are in the agreement with regard to resolving disputes.
Great. So Don asked, this is more of a general question. Can you quickly review the relationship between a non-disclosure agreement and an IP agreement?
Well, an IP agreement is a broad term that covers a number of different types of agreements. A non-disclosure agreement is a particular type of IP agreement. So under the umbrella of IP agreements, one of those types of IP agreements is a non-disclosure agreement.
Right, so Susan asked a question regarding trade secrets or patents. How does a company protect these trade secrets with employees? If your company has a high turnover rate and employees leave, how do you protect your company's trade secrets?
Well, A lot of companies put in place with their employees some type of intellectual property agreement, requiring a new employee to sign an intellectual property agreement that would obligate the employee to keep the company's information confidential, not only during the term of their term of employment, but also subsequent to the term of their employment. So they would have obligations to do that. And taking the next step would be some type of non-compete agreement that sometimes companies use with employees that even goes above and beyond, an employment agreement or a non-disclosure agreement.
So following along those lines, Don asked the question: if you pursue a consultancy in a patent area, would that also break a non-compete agreement? Or could it break a non-compete agreement? It's a better question.
So if someone leaves the company and becomes a consultant?
Correct.
They can consult as long as what they consult in regard to doesn't disclose any of the confidential and use any of the confidential information of their former employer. And as long as they don't have some type of non-compete agreement in terms of that prohibit them from consulting.
Great. So Dwayne asked a question about written IP agreements. Do they need to be certified by a third party, because just the two parties involved actually agree to the IP agreement?
No, they don't need to be certified by a third party. So they can just be, as long as they're executed by someone of sufficient authority within each of the two organizations, that is sufficient to have a binding and enforceable intellectual property agreement.
Great. Looks like we have time for maybe one more question. This is about scientific research fields. So Satori asks, how do you go about intellectual property with scientific finding and research fields? Thus, if you discover something during your research, how do you protect that?
Well, there's different ways to protect it. When you discover it, if it's potentially an invention, you can keep the invention as a trade secret, or potentially you can patent the invention, would be another way. Or if you want to get the information out in the public domain, like in a university type setting, they want to publish the information, to have the information in the public domain so others can build upon it, or use a combination of those types of techniques.
Well, great. So Bob, we'll close the Q&A. We thank you for your presentation today. There's one important lesson you want our listeners to take from your presentation? What would that be?
I think one important takeaway is that it's important for technology people, for people in management that are dealing with technology, to understand the fundamentals of intellectual property agreements, so that when working with other parties and collaborating with other parties, which is becoming more essential these days, that they properly protect their intellectual property interests by having a real good understanding of the basics of IP agreements, fundamentals, which is what the intent of my webinar is going to cover in June.
Well, thanks, Bob. I will now pass this back over to Mike for a closing statement.
All right. Well, Brian, thank you so much for moderating today. And Bob, thank you so much for joining us and sharing all this information. As we are winding things down, I would like to let you know what we have percolating for the next few weeks. Next Wednesday on March 10th, discover how science is an excellent diplomatic tool, as a panel of leaders discuss how diplomacy can be promoted through science and share examples of what it has done in the past. On Thursday, March 11th, we will be teaming up with the Science History Institute and a panel of experts to discuss the future of alternative meats and proteins. You can register now to discover how this coming transformation will affect the future of food consumption, despite the regulatory, economic, and consumer perception hurdles that it faces. Finally, on March 17th, we will be joined by Nick Flynn, a professor of biochemistry at West Texas A&M University, for a beer chemistry happy hour. You can register now to learn some home brewing tips to make the perfect pint, or how to incorporate brewing concepts into your chemistry courses. We would love to hear what you have to say about our program. You can reach out to us through the ACS social media channels on Facebook, Twitter, LinkedIn, or by email at acswebinars@acs.org. We are curious to hear what you thought of today's broadcast, and a short survey will pop up directly after the webinar that will take just a minute to complete. Also, remember that an invitation email to view the recording from today's presentation will be sent to everyone that registered. It will be open for a 24-hour period, after which it will be removed, edited, and posted on open access to the ACS Webinars library. And that wraps up our program for today. On behalf of all of us here at the American Chemical Society, thank you so much for joining us, and we will see you next time.